That lever.
All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So for today's first topic, Phil, this one falls into the category of this is not a surprise at all. But last week on May 22nd, more than a dozen business groups and another company filed a lawsuit seeking to block the Department of Labor's new final rule that significantly raises the minimum salary threshold under the Fair Labor Standards Act white collar overtime exemption, and also requires employers to provide salary increases to millions of exempt workers across the country or reclassify them so they are eligible for overtime. So we've talked about this pretty extensively on the program, that the DOL passed its final rule in just last month. That the exemption under the Fair Labor Standards Act is going up to $844 per week, or the equivalent of $43,888 per year. This takes effect just over a month from now on July 1, 2024. And then it increases again on January 1, 2025 to $1,128 per week, or the equivalent of $58,656. And then there's an annual update that's tied to the 35th percentile of salary in the lowest wage census region, which would be the South, an automatic update thereafter. This is raising the exemption threshold from the current roughly $640 or so per week. Right now, the exact number escapes me right now, but it is a pretty dramatic increase. So these business groups have sued to stop this rule. And so it kind of looks like deja vu all over again with this, as somebody once said, I think Yogi Berra. And this challenge to the rule comes after a U.S. District Court for the Eastern District of Texas in 2017 permanently enjoined a 2016 DOL rule that had sought to raise the overtime exemption. This case, of course, has been filed in that same court. And so people are expecting the same results. I think for right now, people really do need to continue to focus on complying with this new rule by July 1, 2024. It will not surprise me. It will not surprise me if the July 1, 2024 increase goes into effect. And then sometime between July and January 1 of 2025, that this court will sort out the second increase there. So there is a possibility. I think people do need to plan for that July 1, 2024 increase. That could get enjoined, but I think there's also an equal possibility that that increase does go into effect, and then the bigger fight will be over that next increase down the road.
So, Burt, I think if I can summarize this, what I've heard is stay the course, prepare for July 1. Any idea how quick a decision on this gets made?
Yeah, that's a significant issue, Phil, that they have sought immediate review by way of an expedited review. And that's what will be interesting to see if the court allows for an expedited review here. And
Okay,
so we'll have to see what happens. Again, as of now, continue prepping for this July 1 change to increase the minimum salary for executive, administrative, and professional exemption to $844 per week.
Yeah, no doubt. And I mean, I've been working with a lot of employers on this, and we had a roundtable the other day, and one of the employers was just talking about the impact this is having. And it's more so, I think, the second increase than it is the first increase that's causing, more heartburn. But in either case, some businesses, particularly in some of the not-for-profit businesses, and how people are paid, and the mission behind the not-for-profit, it's really raising a lot of havoc. So we will use this as a teaser and say, come back next week for an update.
Yep, and that current salary threshold just struck me again, is $684 per week. So it's moving from $684 per week under this first move up to $844 per week, and then that next move on January 1 would be up to $1,128. So literally almost doubling where they are right now.
Yeah, it's quite a jump. All right, that's good news, Bert. What else do we have on the docket?
All right, so the next one is we also are aware, because we've talked about it on the program many times, that the Department of Labor in the last many months has issued its final rules on independent contractor classification, and there is a lawsuit. Again, Phil, see if you're paying attention. Where's this one pending?
I'm going to guess Texas.
Texas.
Yeah, gotta love the state of Texas, right?
Gotta love the state of Texas. So this case pending in Texas federal court is where a group of businesses are challenging this independent contractor rule. And there was oral argument last Friday on this, and the Department of Labor is arguing that the groups that have sued, the businesses that have sued, aren't actually harmed by this new rule, and that all of the allegations of harm that's going to be caused by this new rule are all speculative. And so that they're saying right now, the DOL argued last week that the alleged injuries are quote unquote purely hypothetical. And so they're trying to get enforcement of this rule upheld in court. Again, it'll be interesting to see whether this rule actually goes into effect or not. This case is sort of in a holding pattern in the appeals court right now, or in the court right now, and we'll have to see what the court ends up doing with this one.
All right. Well, where we have our friends to the south in Texas making a lot of noise. All right. Yeah. Let me guess, you probably have something that's making a lot of noise in Illinois as well.
Phil, you're clairvoyant this morning. It's amazing. Those cicadas are doing wonders for your brain. Yes, I want to give Illinois employers what might be a piece of good news. Yes, a piece of good news for Illinois employers, and that is that the Illinois General Assembly has passed a bill prohibiting claims for what are called per scan damages under Illinois' Biometric Information Privacy Act, otherwise known as BIPA. And this would legislatively overrule the Illinois Supreme Court's decision in Cawthorn versus White Castle Systems. So the Illinois legislature passed this bill to clarify that multiple alleged collections or disseminations of an individual's biometric data constitutes only a single violation of the Privacy Act, and the individual is limited to only one recovery of the statutory damages. This is a huge decision for Illinois employers, because the way the Supreme Court interpreted the bill was to say that every single instance of the disclosure of an employee's biometric data, and think, Phil, of like a fingerprint scan or a retina scan for people who are entering the workplace every day or exiting the workplace, if they unlawfully disclose that information, the Supreme Court of Illinois has held that every single time the employer does that, it's a $1,000 to $5,000 penalty per scan.
Oh my goodness! Yeah.
Yes, and so this could be literally turn into catastrophic litigation for a company. If you think about it, if they have hundreds of employees and they do this, in the morning and in the afternoon, and they do this day after day, and it goes on for a couple of years, it could literally put the company out of business. And this has become a favorite area of class action for Illinois plaintiffs' attorneys over there. This law clarifies that employees would be entitled to only one recovery of between $1,000 and $5,000, and that if the disclosure is ongoing, that's just one offense. So,
I wonder, Bert, not to cut you off there, but I wonder if like a facial scan would be considered, like a Face ID that you use on your computer. My computer has Face ID, it scans and it knows that that's me, and then it will unlock itself, as an example. I wonder if that would qualify as biometric.
I think that does qualify as biometric, but not within the purview of this law.
Okay, gotcha.
Okay,
Yep.
so
Right.
this law does not apply to that. So this one is really going after employers, targeted toward employers who use biometric data in the workplace.
All right. Very good. That's well, maybe some good news for our friends in Illinois, and we'll have our friends in the South keep up the activity down there. And maybe somewhere through there we can go out and make a buck in this process.
Perhaps.
You know, the word BIPA, right? For the biometric, I'm going to start calling you the big BIPA. That's a good one, isn't it? You're going to be the big BIPA. It's just a fun thing to say.
It is an odd acronym, isn't it? BIPA.
It is. It is.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.